First of all, I would like to inform you that this morning the challenge hearing filed by the prosecutors was held, which ended up before the review court. The reality was as follows. The court revoked the judge's decision granting Konstantin house arrest, arguing that it had not been sufficiently substantiated, that the reasons had not been adequately set out, even though situations involving a risk to life were involved. The doctors were heard, and the court accepted what, in our view, was completely unfoundedly introduced by the public prosecutor's office, namely, the claim that they had requested the intervention of the forensic medical body. This is not the case. I made this clear to them because there was no adversarial process, and the prosecution consented to it. Not only did it consent to this specific hearing, since it appointed its own experts, but the judge, without it having been requested by Zapata's party, also summoned the doctors from Unit 6. All of the doctors intervened in order to continue the proceedings and to reach a conclusion as to whether the life of Konstantin Rudnev was at risk. The conditions of tension had worsened, and everyone, the party-appointed expert, our expert, and the expert of the public prosecutor's office, stated that there was danger and that the health conditions had deteriorated. In our view, there was indeed risk, but in the opinion of the party-appointed expert, there was no imminent risk, meaning that he would not die today, tomorrow, or in 2 days. This has no parallel whatsoever, since what was at issue here was whether Unit 6 of the Penitentiary Service was capable of providing adequate custody and care for the health of Konstantin Rudnev. The truth is this. It was acknowledged that they cannot adequately monitor him, that when Konstantin writes in Russian, they have no way of translating it, and that unless they make him speak in Russian so that Google Translate, which inaccurately reproduces what Rudnev says, can translate it, there is no way to communicate. The court also erred by allowing the prosecutors to confuse the court, as they stated that he had refusals and that he had refused to receive medical care. On the contrary, it was proven. We offered the links contained in the case file so that they could be checked. The Konstantin accepted the transfer to Santa Teresita and accepted the interventions carried out on him within Unit 6. However, never ever were the studies agreed upon by all the consulted doctors from Santa Teresita, pulmonologists and cardiologists able to be carried out due to shortcomings of Unit 6. All of this was not addressed, and most importantly, within 24 hours, starting tomorrow, we're going to request a review of the decision to revoke the measure by the challenge court in which 2 judges intervened. These 2 judges will not be able to intervene again, and it will be other judges who decide whether the decision was arbitrary, whether they departed from the guidelines of the challenge, and whether they went beyond their authority, acting as if they were a court of cassation, which they are not, taking measures without an adversarial process, and stating that the forensic medical body must intervene. All of this is entirely arbitrary. We will set this out, and we believe that in the review appeal in General Roca justice will be done, granting immediate house arrest to a person whose health condition is worsening, and where this may end up causing his death. I hope it is resolved very quickly before next week. Thank you.